voluntary, it's confidential, and you're keeping it in your hands. You're keeping the decisions that affect your life in your hands. And as an attorney, when I'm representing, you don't have to be an attorney to be a mediator, I should tell you that. But as an attorney, you bring, of course, your legal experience and your knowledge of the law to the mediation. But as a mediator, you're always clear to explain to your parties that even though you're an attorney, in this capacity, you are a neutral party and you are a facilitator. You are facilitating their agreement. You do not represent either one of them, and you always have to make that clear. And you always advise them at some point, if only at the very end when their agreement is done, that they have it reviewed by independent counsel. But it's a wonderful profession, and neither party goes away angry because nothing's being imposed on them. Nobody's making the decision for them. They are making an agreement that they can live with. So, does anybody have any questions for me about that, or?
We'll save the questions for afterwards if we could. Robin, do you want to continue?
Hi, my name is Robin DiGiamarino. I am an example of someone who is a mediator, not an attorney. I'm on my third profession. I started out working in healthcare with physically disabled adults. I ran for public office, served on a school board for 5 years. That piqued my interest in conflict. And moved back. I mediate in the district courts. I serve on several panels with MWI. I also mediate workplace discrimination cases for the Boston office of the Equal Employment Opportunity Commission. I also mediate public housing disputes across the state of Massachusetts. And my passion is teaching people about mediation. And I enjoy working with folks at other law schools who are trying to gain skills. And I think one of the reasons I agreed to come at Christina's invitation is mediation to me is a life skill. We all do it. If you are living and breathing and living next to someone, you are mediating all the time, whether it's the dirty dishes, whether it's your standards for cleanliness, whatever it is. And to be able to have those life skills as an attorney, to be able to be a better advocate for your clients, I'm a strong believer. So I'm here to just share a little bit of my story about that and look forward to hearing some of your questions.
Thank you, Howard.
Yeah, thank you. I'm Howard Corney, and very pleased here to be the thorn among roses. Also the gray head. I'm now in my 41st year as a practicing attorney, which means I started out before any of you were born. I don't practice full-time anymore. My latest gig was with a law firm called Nixon Peabody in their Boston office, where I was for 20 years. And for many years ran their bankruptcy group, which meant that most of the time when I met people, they didn't want to shake my hand. As a result, when I got into mediation, I followed my instincts and did, and still do, commercial mediation. I do a lot of bankruptcy mediation. In my association with MWI, I also mediate commercial disputes largely because of their contract affiliation. Disputes between General Motors and their dealers who have disputes over warranty items and also over compliance with the promotional programs that you may see advertised on TV. It's not worth going into at this point, but if appropriate, I would later on. Contrary to what Mary Ann said, I don't always find that people walk away happy. But what I try to achieve is what a wise judge once told me, and that was that a very good settlement, which is what a mediator tries to achieve, is where both sides walk away equally unhappy. That very often happens. Sometimes it happens where they are both pleased, but what you try to do is get them to a resolution and facilitate a settlement. The best thing about, well, I shouldn't say the best thing, but one of the nicer things about mediation is that the settle, you don't settle. The sun comes up tomorrow and you'll still have lunch. So it just shows that you have no stake in the venture, you don't have a dog in the fight, you're totally neutral, just trying to bring the parties together so that they can perhaps see reality, which is another point that we may get to as things go along.
Thank you, Howard. Megan? Hi, I'm Megan. I'm a mediator, trainer, and staff member at MWI. And I can talk a bit more about, as I said, the contracting work that we do and what that looks like in the program management aspects of that. My background, very different than other people coming up, is I'm not an attorney. I did a master's degree in conflict resolution and transitional justice at the University of Cape Town in South Africa, and got into the field with a really academic interest and wanted to go into either becoming a professor or working in the think tank world. And while I was working with a nonprofit there, I saw a great need in the community for building skills and for helping people learn more personally and on an individual and community level about how to mediate and how to negotiate. And so that brought me here and to MWI with a passion for spreading the sort of word about mediation and helping people develop these skills. And I mean, you have an amazing panel here today. I know Robin has done almost 500 mediations with MWI. Howard comes with an amazing background in commercial mediation and bankruptcy, both as an attorney and as a mediator. And Marianne does so many divorce cases with us and is someone who is very highly regarded. So definitely draw on their knowledge. The cases that I do right now are mostly summary process and landlord-tenant cases. I also do, similar to Robin as well, public housing cases. And there's a great need for attorneys who understand mediation. So thank you very much for being here today and being willing to learn more. Awesome, thank you guys. I want to start a little bit of a discussion on the kind of evolution of the practice of mediation. I know that after having been trained, I heard nothing but great things about how it's been evolving so much and how kind of the choice to mediate is sometimes outweighing the choice to litigate. And how do you see that happening now? And as an attorney, how many cases, I guess, do you see where they say, you know what, I don't really want to go to court? And what kind of benefits, as someone who's not an attorney, do you see from them choosing to mediate instead? Do you see kind of an emotional, off the shoulders? How do you see that evolution of mediating kind of assisting in these problems and disputes?
Looking at it from my end, I still encounter a resistance to going to mediation. If I could use my experience with the bankruptcy bar, there's an attitude that, it encompasses a couple of things. One, the attorney feels that by going to mediation, they'll lose control of the case. And secondly, they feel that that the mediator doesn't possess any greater skills than they will in settling. The flaw in that, of course, is that they're so invested, as some of you may be when you are in private practice. They're so invested in their case and so eager to serve the client, as we all should be, that they sometimes lose touch with reality. And one thing that the mediator can do, diplomatically of course, is point out weaknesses in the case, bring the parties down to earth, realizing that a settlement means that you're not going to get the other side to capitulate, you're not going to get 100 cents on the dollars. Instead, you're going to have to compromise. If you do get to mediation, and I will say that there is a trend more in my area, more toward going to mediation, although a lot of times the bar gets dragged kicking and screaming into it, sometimes by order of the judge. One of the best things a mediator can do is advise the parties that their case is not unflawed, that there are aspects to it that are non-legal in nature, and that you got to sometimes look at the pragmatic as opposed to going around the book.
Please, anyone. And a big phrase that we use when training is a big part of mediation is that you're trading hope for certainty. So as attorneys, you know that you build an argument, and your role is to present to a judge, this is why I think I should win. And you might put the best argument together that you can, and depending on the judge, they might not agree with you. And I think what's great about mediation is that you can go into a room and have an assisted negotiation, where if the other side has been unresponsive and you're not sure if the judge is going to like your argument, you have a chance to work out a deal that's best for your client. Robin?
I was just thinking, there's a lot of political talk about who should be able to mediate, who's qualified to mediate. And so I'm not going to touch that, but just know that's there. That's out in the community about who is qualified to be mediating. I think when I see parties who are, as Howard says, sent by the judge into mediation, they come in with a chip on their shoulder. It's not their choice to be there. But one of the principles of mediation is that it's voluntary, and to be able to let them be making their own decision about whether they stay. And people are sometimes pleasantly surprised that after having this pent up, I want to be able to tell my story and have someone actually listen, and being able through the mediator to hear more about what the other party's perspective is, and coming up with something that they have designed on their own makes a huge difference. And just an example of that, landlord-tenant cases, landlord comes in, filed notice to evict, tenants comes in and says, well, I can't pay. And in discussing what's important to the landlord, having someone in the apartment that will pay, decides, surprise to the mediator, I'd rather pay this guy to get out. I'm going to let go of that $11,000 they owe me because I want to get someone in my apartment that will pay. Never could have predicted that. They came expecting that person to get evicted. And the mediation decided that what was most important to them was a paying tenant, get this other person out, paid for a T card, paid for storage of belongings, paid for moving, and that expense was worth it to them because in the end, they wanted them gone. So experiences like that make such a difference in knowing that mediation can work, and even though people are resistant to coming, sometimes it works out.
I find that people, well, one thing, a lot of people still don't know that mediation is an option. Now, I'm talking now about divorce mediation. So there needs to be more education about that, I feel, because a lot of people, as I say, they really don't know that it's an option or know what it means. Most of my clients, I need to explain it to them. They've heard about it, and then they come for a consultation. I tell them what. Some clients are referred to me by judges. Some clients that I've had with mediation works have come because they're ordered to come, which is kind of counterintuitive where it's a voluntary process, but again, they don't have to stay. Others it's suggested by their attorneys because, for a number of reasons. One, because the two attorneys, one for the husband, one for the wife, just can't get them to cooperate. Sometimes it's because the client's money is running out, and the attorneys really want them to settle because they're not going to be able to pay them for much longer going, the way they're fighting. But one case I had that is kind of a seminal case, and I mentioned it earlier to one of your fellow students at lunch, was a couple who had been divorcing for 5 years. 5 years. They were each on their third lawyer. That's 6 lawyers. 6 litigators were getting paid. These clients had a lot of property and a lot of assets, and they hated each other. So, really, I mean, the things they said to one another, it was awful. But anyway, they came, and they had a pretrial conference coming up, and their lawyers, again, they were ordered to come because the judge had it. And it took about 3 hours the first day, and without their attorneys, and they brought their attorneys. They fought with them, they fought with each other, everybody was fighting, and one time or another, but bottom line is, it took 12 hours, but again, they've been doing it for 5 years. They had an agreement to go to pretrial with. I am very proud of that case, and they were very, and they were happy. As much as they hated each other, they both liked me, and they liked the fact that they got their agreement done, and they could stop paying the lawyers. The bleeding was stopping. So, I don't know if that answers your question at all, but it's just so interesting where the clients come from, and that there's room for litigators. Even if you're litigating, you can use mediators.
That's an important point, that when a mediation is successful, the ultimate result is certainty. And what I tell a lot of the parties for whom I mediate in business, I tell them, don't put your heart above your head. It's time to make a business decision. Is it worth it to go to litigation for X amount of dollars as opposed to settling for whatever is on the table right now? Most of the time it works. Sometimes, and what you've got to watch out for as a mediator is when a party comes into mediation and is either suing or defending solely on principle. You know, I'm not going to let that son of a bitch take 1 cent out of my pocket. Well, that makes it more difficult, obviously. And that's when you really have to delve into where they're coming from and why. Is it, for example, is it because they did business with that person and didn't get paid, and that is something that is absolute heresy in their eyes. It makes it, as I say, much more difficult to try to achieve a settlement, but obviously that's why they pay us the big bucks. That's why you're there trying to facilitate a settlement. It doesn't always work, but it's got to be where the mediator sometimes looks the party in the eye and says, as diplomatically and tactfully as possible, you're wrong. You've got to see it this way. What I try to do is I look at it and I say, have you considered X? Have you considered the consequences of Y? X, Y, whatever. Sometimes you're doing it over the advice of their own counsel, because a lot of times they bring litigators in, and litigators love nothing more than to go to court. That's what makes their juices flow. So, they sometimes are a bigger obstacle to a settlement than the client. And so you got to be sensitive to all of that, those dynamics.
I just have a question for the room. How many of you, can you raise your hand, have you participated or been part of a mediation?
Does arbitration count?
Sure. No, personally, outside of school. Have you been?
Oh, I'm sorry, school.
Okay.
How about an arbitration?
Yeah.
Arbitration.
Yeah, all right.
By the way, do you know the difference?
Yes.
I'm sorry to patronize, but
Yeah.
just for those who don't, arbitration is mandatory, where the arbitrator sits in the middle, listens to the evidence, makes a decision, and that's binding. Chapter 251, Massachusetts General Laws. Mediation is obviously, as Mariana said, and Robin said, a voluntary procedure. You don't like what's going on, pack your bags, and leave.
Well, the reason I asked about what your familiarity is, one of the things I hope that you pique your curiosity, so you learn about mediation. As attorneys, I think you can be better advocates for your clients if you at least are familiar with what the principles of mediation are, what the process might be like, so that when you go in with a client, you know something about that. And also to know as a mediator that I enjoy having attorneys coming in and representing their clients, because as a neutral third party, I may have an opinion and a thought about what maybe that person should do or not do. I can't say that in my role as a neutral, but I'm so relieved when counsel says to client, you really should take that, because the reality is these are the things that we're going to have to test out, and it's going to cost more to stay and go on to court than it would be to resolve a mediation. So, one, I hope you learn more about mediation. I know Mary's talked a little bit about it, but the 5 principles, and if I'm telling you things you already know, then just say time. But that it's voluntary, that the conversation in that mediation will be confidential. There are some exceptions, harm to self or others, or abuse of a child or an elder. That the mediator is there as a third-party neutral. We have opinions. We're not a blank slate, but our job as professionals is to not share that. If I'm working with Mary Ann and during a caucus, I might say, don't like that person at all, reminds me of my college roommate. When I'm mediating, that's not coming across. I follow a facilitated approach to mediation. I'm really looking to make sure that the parties talk about what they're wanting to talk about. That's up to them, that's self-determination. I'm in charge of the process for it. And then I want to make sure I have the right people at the table. And I'll tell you, as a new mediator, I mediated a small claims case. It was a brother-sister, furniture, things that needed to be removed from an apartment, get to the whole end of it, and then one of the parties says, well, I really can't make that decision, I have to call so-and-so. So I've wasted my time, their time. So you learn by doing, but if you understand those principles are key, and also think about what you could do to learn to be better advocates for your clients in terms of mediation skills.
That's perfect. If I could, I want to direct a question to Robin and Megan as coaches and trainers. Having been trained as a mediator myself, I know that you were trained to really focus on interests. And would you mind talking more about that process of focusing on those interests and how maybe finding out about more than what the real problem is can lead to benefiting the client so much more and leading to a better outcome? So if either one of you